What I'm going to talk to you about is the scourge of tree root encroachment. And given that the name of this talk, or these talks and seminars, Pandemic Property Pitfalls Seminar, you might well wonder why on earth I'm talking about the scourge of tree root encroachment. But I have found a link. There is quite clearly a link, which you've all probably got to a lot quicker than I have, and that is that lots of you have probably been planting trees in your gardens next door to your neighbour's property during the course of the pandemic and during lockdown. So that is why in about 20, 30, 40, 50 to 100 years' time, there are going to be a lot more claims for tree root encroachment. So I'm sticking to that particular argument anyway. Right. I don't know how many of you know anything about tree root encroachment and the mechanism by which damage occurs to properties, but I'll come to that. I mean, one thing of interest at the moment, we're all talking about climate change, is actually what is going to be the impact of climate change upon tree root claims. Because on the one hand, we may have much higher temperatures and less rainfall. Conversely, which obviously more temperature, less rainfall, will have more tree root cases. Conversely, we may well have more rain, much heavier rain for prolonged periods, heavier rainfall during the year, such that we'll have fewer tree root claims. So quite how it's going to go in the future in the light of climate change will be interesting. So far as the mechanism of tree root encroachment and damage is concerned, let me just deal with that. You've got to have a number of things to have damage in this instance. You've got to have tree roots extending under the foundations of a property. They've got to be going under the foundations. Secondly, you've got to have a shrinkable clay subsoil. We've got some of that in Bristol, not enough, unfortunately, but quite a lot. And certainly the council does have problems in this city as they do in Swindon, and particularly in London. What you've got then is you've got tree roots growing under a foundation. The tree roots extract moisture from the soil. It being a clay, shrinkable clay soil, as the moisture is extracted from the clay, then the volume of the clay subsoil reduces. So you get shrinkage of the clay subsoil underneath the foundation. And if you get the shrinkage of the clay subsoil, then you're likely to get dropping of the foundation and consequential dropping of the superstructure relative to the rest of the property, which may not have moved. So that is the mechanism behind these claims. And one of the critical indicators of this kind of damage is that you get seasonal movement. So during the summer months, cracks will develop, and then every year thereafter are liable to open up, increase in size. But then during the winter months, from late autumn onwards to early spring, when you've got more rainfall, the cracks start to shrink. Now, cumulatively, they actually grow over time, but from year to year, they'll open up in the summer, close in the winter. And if you see that seasonal movement in a property, the primary candidate to blame is a tree or some type of vegetation growing in reasonable proximity to the building. So that's the mechanism. What is the law and when does it give rise to liability? What we're really talking about here is a measured duty of care. Which is now become the popular term, really, particularly when looking at the duty of care in respect of naturally occurring nuisances. So we're talking about flooding, we're talking about trees falling across roads, we're talking about tree root encroachment, where you have a natural cause of damage which occurs. And what the court's talking about in respect to the measured duty is fairly well set out in the first paragraph of the notes that I've done in the case of Soloway in Hampshire, which was a tree root case. And the Court of Appeal said the duty in respect of the nuisance created by the roots arises if the encroachment of those roots is known or ought to be known to the owner, occupier, or other person responsible for the tree and its maintenance, if the encroachment is such as to give rise to a reasonably foreseeable risk that such encroachment will cause damage. So we've got to have encroachment and reasonable foreseeability of the risk. Those are the first two aspects we've got to have. There is then a third aspect in that there's got to be a failure to take reasonable steps to address that foreseeable risk. And so you have this, what they call the measured duty. It's reasonable foreseeability tempered by the need to take reasonable steps to prevent damage occurring due to that foreseeable risk. So in the case of Solway in Hampshire, this was a case down in Southampton where there isn't a great deal of shrinkable clay subsoil. And in this particular road where this damage occurred, there were some pockets of shrinkable clay. And there happened to be a pocket underneath this particular property. There weren't pockets under all of the rest of the properties in the road, in fact, very few of them. And the court took the view that it was unreasonable to expect the local council to be aware and test for the precise location of individual pockets within their borough. That would be demanding too much of the council. And therefore, the council were not found to have been at fault in failing to identify the risk of damage to this particular property, because they were not to know at all that this particular property was founded upon shrinkable clay. Now, that is a defence which can take a defendant just so far. But the moment you get damage to a property and it is reported by the property owner to the tree owner, then further damage is immediately reasonably foreseeable, because you know that damage has occurred and therefore it's reasonably foreseeable to expect that there will be further damage in the future, assuming it is tree root related. And given you've been told about the presence of damage, you know that there are trees nearby, then you as an owner of the tree would be expected at least to consider that the damage was caused by tree root encroachment, and you would need to carry out investigations to deal with it. So once you know there's been damage, you have that foreseeability. But in the stage before you know about any damage, the question of reasonable foreseeability arises, and you may well have a difference between what should be foreseen by a local council on the one hand and by a private property owner on the other. A local council would be fully expected to know about the geology of its area. An individual house owner, much less so. But we get to a point where actually I've set it out here, the case of Carn and Harrow Council at paragraph 7 of my note, where the court took the view that there is now sufficient media reporting about property damage caused by tree roots for people generally to be aware of that risk in general terms. That is not to say that damage to this particular property by this particular tree should be reasonably foreseen, but it clearly does heighten the hurdle for a defendant to get over to say, we had no idea this might occur. It's quite a difficult burden to get over by just saying, look, I know there's a very big tree standing there, but I had no reason to think it would affect this property. The court will likely take the view, well, look, you must have known something about tree root encroachment and potential damage. A lot of you might think that's wholly unreasonable, but it appears to be the view that the court has adopted, and certainly adopted in the case of Carn and Harrow Council. One of the interesting elements of the issue of foreseeability is this. You as a defendant counsel, with your planted trees around a development, and 30, 40 years later, you're facing a claim because there's been true root encroachment under the property caused by the vegetation that you have planted so kindly for the aesthetic well-being of the place. The council may well argue, well, look, this property was constructed following the implementation of building regulations. The property was inspected. The foundations have to meet the NHBC requirements in accordance with the building regulations. It's entirely reasonable for us, the council, to assume that the property was built to satisfy those regulations and those requirements. Therefore, damage is not reasonably foreseeable. Now, I mean, I've run that argument once and failed with it. Judge, not excited. There is another first instance decision of Siddiqui, a case I've made reference to within my notes, where the judge took the contrary view and said, yes, modern housing, it's reasonable to believe that if the property is built in proximity to a tree which is existing, then you could expect that the foundations have been designed and constructed to take into account the proximity of that tree. Now, there may be a distinction to be drawn here between my case, where the property is built and vegetation is put in quite close to the property at the same time, and the other case where the tree's been in existence for a long time and a property is built nearby. Now, one would expect a property built nearby to a big, beautiful oak tree to be designed with appropriate foundation depth. And if it's not, is it right to blame the council whose tree this is? And one then comes up against the argument, this beautiful oak tree, which has been there for about 400 years, is of great value to the community. Should it be being felled, or should the local council have to pay for underpinning to this property in order to be able to retain the tree? So one gets to quite interesting questions at that point. Questions, I have to say, which the court is not always particularly interested in, but you can see the dilemma that arises in this situation. And that really rather takes us on to the point about what are reasonable steps to be taken by a tree owner once they are aware of the foreseeable risk. And one of the difficulties comes that there are many arguments around, such as, well, a council should prune the trees back. If you prune the trees back, you reduce the amount of leaf area and you reduce the amount of transpiration through the tree, and as a result, you reduce the amount of moisture extraction in the soil. Therefore, you're going to reduce the amount of damage that might occur to a property. The trouble with that is it doesn't always work particularly well, pruning, in having that effect. Secondly, you've got the problem, if you're doing pruning, you're going to have to be repeating it every couple of years, and that may not always happen. The other alternative that may be brought out in argument is about of a tree root barrier, where basically you put a big wall down into the ground, extending for however far it may be, and that tree root barrier should stop the tree roots coming through the barrier or around it, and hence get at the property that you're trying to protect. Well, again, it doesn't always work, because inevitably the tree roots find their way around it one way or another quite often. So the courts are not particularly excited by those as being reasonable steps, and you won't get many expert engineers or arboriculturalists who will necessarily support those kind of approaches. So what you're left with is either the option of felling the tree and therefore stopping the risk altogether, or the option of underpinning the foundations of the property, thereby allowing the tree to remain in place and for its roots to continue to grow in the direction of the property. So the question then arises, what is reasonable for a defendant to do in these circumstances. And the case of Soloway, which I referred to, was followed in the case of Delaware Mansions and Westminster City Council in the House of Lords, as it was back in 2001. And Lord Cook, who hails from New Zealand, and that might explain why he comes up with this slightly nebulous approach to the problem, accepts the law in Soloway and goes on and says the answer to the issue falls to be found by applying the concepts of reasonableness between neighbours, real or figurative, and reasonable foreseeability, which underlie much modern tort law, and more particularly the law of nuisance. So applying the concept of reasonableness between neighbours was put into effect in the case of Delaware by saying that the council should not have to pay for any underpinning of the property unless the property owner had told the council that they were going to underpin and incur the very large cost involved in underpinning. It was only reasonable, as between neighbours in this type of case, that the tree owner be given notice of the extent of the remedial works that were proposed, because the council had an alternative. If they were told it's going to cost several £100,000 to underpin the property, the council has the option then of felling the tree. All right, the council may say, no, we're going to keep the tree and we'll pay the damages. But they might take the view, we'll fell it because we simply can't afford to spend £200,000 on underpinning your house. So that is a particular area where this principle of reasonableness as between neighbours comes into play. Now, we've had subsequent cases where councils have complained that they weren't told about the intention to carry out underpinning, and the court has actually said, look, you were never going, even if you'd been told, you would have paid for the underpinning because you would have wanted to keep the tree, and that was just inevitable. So you can't just always apply Delaware to all cases. One's got to look at them to see whether in the circumstances of the case the owner of the property has been reasonable apropos the tree and the owner of the tree. So that deals really with foreseeability and the issue of reasonable steps. The other significant issue that arises in these tree root cases is the issue of causation. And that is really where most of the attention goes. You have expert arboriculturalists, you have expert engineers who bring their expertise to bear on these respective issues. Firstly, as to what it is that caused the movement of the property. Okay, so we've probably got seasonal movement, so the likelihood is it may well be vegetation. But the next question is, which bit of vegetation was causing it? Was it the vegetation in the property owner's garden that was causing the movement, or was it the tree in the next door neighbour's garden which was actually causing the problem? Quite often, you may well have a contribution from both. And the critical question is, and I've set it out at paragraph 11, did the drying of the ground caused by the particular vegetation concerned materially contribute to the damage? So it doesn't have to be the sole cause of the damage, it's got to be a material contribution to the damage. So causation issue will also go not only to the question of which bit of vegetation or caused the damage, but also are there other things at work here which have caused the damage other than vegetation? So, for example, you might have damage caused by settlement of the ground. So, for example, if the property was constructed on fill material, you may get that kind of settlement without any involvement at all of tree roots. You may have leaking drains, again, which may well cause movement of foundations downwards, unrelated again to vegetation. And Usually, though, the reality is that if you're getting seasonal movement, there is going to be some involvement of tree roots. Whether it reaches the point of being material is questionable. But in many cases what happens, and there's one case called Brown and Swindon Borough Council, in which we were involved, where basically the tree roots were found to be responsible for 30% of the damage, and other movement in the property was responsible for the other 70%. So you can get these divisions of responsibility as between the different types of damage that occur. So it's always an important issue, and if you go through all the cases that I've been referring to in my notes, you'll find many, many pages dealing with expert evidence and with the issue of causation. So not the most exciting read always, but it's highly important in these kinds of cases. Let me deal with one specific different issue, and that is the effect of a tree preservation order. If you've got this lovely big oak tree in the next door neighbour's garden and you're complaining about the fact that damage has occurred to your property, you go and complain to the owner of the tree, and he said, well, there's absolutely nothing I can do about it. The council have slapped a tree preservation order on this tree. Therefore, nothing I can do, not my fault, I can't take it down. Well, there's a case of Perrin which dealt with that, which is at paragraph 13 of my note. And the case draws attention to section 198, subsection 6 of the Town and Country Planning Act 1990, which says, without prejudice to any other exemption for which provisions may be made by a tree preservation order, no such order shall apply to the cutting down, uprooting, topping or lopping of trees which are dying or dead or have become dangerous. Now that probably applies much more to falling trees than to tree roots, but it may be that you can say that tree roots which are coming under the property and damaging the property have indeed become dangerous. But it is covered by B quite clearly, which relates to the cutting down, uprooting, topping or lopping of any trees in compliance with any obligations imposed by or under an Act of Parliament, or so far as may be necessary for the prevention or abatement of a nuisance. So if we've got tree roots growing under the property next door, we have a nuisance. So in fact, the owner of the tree can fell the tree in order to stop the nuisance. Now, obviously, the owner of the tree is going to be somewhat wary about doing that, knowing that if he gets it wrong, he may well be fined and prosecuted by the council. But conversely, if there is a nuisance and the owner of the tree has got the expert evidence to say that, look, this tree is causing a nuisance under the next door neighbour property, then the owner of the tree has actually got some weight on his side and may well not get prosecuted by the council. But you can well understand that the tree owner is going to be wary about how he copes with that. And so he's going to put his hands up and say, look, nothing I can do about that. But the critical thing to bear in mind is it's not the property owner's problem. It doesn't provide a defence in any way for the tree owner to say there's a tree preservation order there. The claimant, the owner of the property, can say, I don't mind about that. You've got to deal with it. Either you chop it down or I'm going to sue you. And so it's really the problem of the tree owner who's got to engage with the council to try and deal with it. And if the council say no, well then the property owner's on his own, having to deal with it. But the critical point to take away is a tree preservation order is not a defence, effectively, against a claim for damages in nuisance. Who can sue? Well, effectively anyone with an interest in the property may sue in respect of damage. And importantly, if damage occurs during one ownership and the property is sold to another person, the subsequent purchaser can bring an action against the owner of the tree for the damage that occurred to the property when in the ownership of the previous owner. And that was derived from the case of Delaware and Westminster City Council. And what really lies behind that kind of reasoning is that the nuisance is a continuing nuisance. And it's very important to bear that in mind, because so much of the debate about limitation in this kind of case arises from the fact that it is a continuing nuisance. So you may well get damage which occurs in the year 2000, let's say. No more damage occurs until 2006. All right, so we've got to the end of the limitation period for the first damage. And then damage occurs and a claim is brought on the basis of the actual damage that occurs on the second occasion, but also to protect the property against future damage. So they're going to claim for the cosmetic work to the walls, but they're also going to claim for the underpinning of the foundations. That is to protect against the continuing nature of the risk. The claim for the original aesthetic damage to the walls back in 2000 may well be time barred by the 6-year limitation period, and the owners would not be able to recover in respect of that damage, the original damage. So whilst there's an argument that you can try and say, look, it's a continuing nuisance, therefore I should be able to claim for the damage that occurred in 2000, there is a very real chance, and a chance that one shouldn't take on board at all, that a court will say, no, there's a 6-year limitation period following that original damage, that specific damage, even though subsequent damage can be alleviated by underpinning and the cessation of the continuing nuisance. So it's an important point to bear in mind if ever you have such a case. The conclusion, effectively, that I've set out for you in the notes is actually just to set out a passage from Leakey in the National Trust, which simply goes to demonstrate the exercise of the measured duty of care in this kind of case involving a natural nuisance. And the decision of Leakey is applicable to flooding, it's applicable to trees and to other natural nuisances. And it's this measured duty of care which has the balance of reasonable foreseeability on the one side against reasonable steps to alleviate against that reasonably foreseeable risk on the other. And whether you call it a measured duty of care, whether you call it reasonableness as between neighbours, I leave up to you entirely. But that is what underpins, sorry, I didn't mean to use that word, that's what really underpins this area of the law. Right, I think that's me done. Thank you very much for listening.